Hi, my name's Isaac Schutt. I'm an estate planning attorney licensed both in Texas and in Wyoming. Today I'm going to talk about the determination of heirship. A determination of heirship is a legal process that a deceased person's estate might go through if that deceased person died without a will. We call that dying intestate. If the person died with a will, then the determination of heirship is typically not going to apply unless that will was invalid. But if the person died with a valid will, determination of heirship is not going to apply. Okay, so what is a determination of heirship? A determination of heirship is a legal process where basically an heir files a request in the court with probate jurisdiction to say, hey, judge, I would like a piece of paper, a determination of who the heirs are. Now, with that legal determination, then you can go and deal with whatever assets there might be. So if there was real estate, that determination of heirship is going to say who gets that real estate or bank accounts or whatever. So basically, the determination of heirship is kind of like the state's will for you if you died without a will. So that's the way you should sort of think of this. If your loved one died, that determination of heirship is going to say what shares all of those heirs are going to get. And so it is a legal process. You're going to have an attorney to go through the determination of heirship process, and it's not necessarily a fast process. So I'll tell you, our office is here in the Dallas area. We have a lot of what are called statutory probate courts. And what that means is these judges do nothing but probate cases. And so they deal with a lot of determination of heirship cases. So for a frame of reference in our local statutory probate courts, it can take anywhere from a month to 6 months or more for a typical determination of heirship to work its way through the court process from the time we file the petition to request a determination of heirship all the way through the time that judgment is actually signed. Now, let's talk a little bit about what that process looks like. So it's typically going to be filed by one of the heirs, and the petition basically lays out the family and marital history of the person who died. And so that application is prepared by a lawyer, and it's signed and notarized by that petitioner. Now, from there, the petition gets filed with the court, and the court will do some sort of behind-the-scenes things like posted notice, published citation, making sure that all of the people who might claim to be an heir are on notice that they have a chance to claim their heirship. And that after that notice and citation period has run, the court will appoint an attorney ad litem. Now, the attorney ad litem is just an attorney like me, licensed here in the state, whose job it is from the judge to go and fact check the petition that you filed. So they're supposed to be kind of neutral, and their job is to report back to the judge, hey, judge, either I think there are unknown heirs, or judge, I'm confident there are no unknown heirs. All of the heirs have been correctly listed in the petition. So that attorney ad litem gives the judge some confidence that what you said in your petition is actually accurate. Because think about it. Of course, you're going to say you're an heir. You're trying to get money. So the law is not designed to trust you as the applicant. We have this attorney ad litem to go back and provide some independent proof for the judge that there are no unknown heirs out there. So the attorney ad litem does their thing, and then typically we'll have a hearing. Now, by the time we get to that probate court hearing, the case is pretty much uncontested, because if there were any issues uncovered by the attorney ad litem, they would have wanted you to address those before you get to the hearing. So by the time you get to the hearing, it's more or less a walk in the park. Now, do keep in mind that for a determination of heirship, you're going to have at least 2 disinterested witnesses participate in your hearing. So, when you file your application, you want to be thinking about, friends or neighbors or, church friends or whatever of the deceased who would be willing to come to court for your probate court hearing to say, under oath, with their right hand raised, yes, Judge, I'm confident that this deceased person did not have any other heirs. I believe those were the only marriages and those were the only children or whatever. And so be thinking about who you want to use as your witnesses when you file the application, because your attorney ad litem will want to speak with those witnesses as soon as the attorney ad litem gets appointed. And then after they speak with the witnesses at the hearing, those witnesses will be used again in the hearing to provide some proof in an independent fashion that those are the true and correct heirs. So then, if the judge is convinced after hearing from your witnesses and hearing from the attorney ad litem that there are no unknown heirs, then the judge will sign off on your judgment determining the heirs, and you're pretty much good to go. That is basically like having a probated will of that deceased person, and that transfers all the assets. Now, I'm going to say 99% of the time when our probate law office does a determination of heirship case, we also request an administration. And what that means is that we're going to have the equivalent of an executor appointed. And an executor is the person who goes and actually transfers all the assets and makes sure that all of the deceased person's debts are paid up, make sure that the deceased person's taxes are squared away. So that executor person would be the person who does that. When there's no will, so like in a determination of heirship case, we don't call them an executor, it's called an administrator. And if all the heirs can agree, it'll actually be an independent administrator, which is way better than just an administrator. So if all the heirs are in agreement and getting along, they can all sign a piece of paper that says they're in agreement with having, X person serve as the independent administrator. So in that same court process where you're getting the heirs determined by the judge, you can also ask for the judge to appoint one of you as the independent administrator. And then that way you have a person that can go and deal with all those debts and creditors and, pay back whoever dealt with the funeral and burial, pay back whoever paid the probate attorney fees, and then divvy up all the remaining assets after all that's been taken care of. So, like I said, in the vast majority of cases, when we do a determination of heirship case, it's going to be a determination of heirship with independent administration. And you are required to have an attorney if you're going to go through this process. And buckle up, this is not an inexpensive process. I think you should budget at least $4,000 or even $5,000 at a minimum. So don't be surprised if an attorney asks for you to pony up a retainer deposit when you get started, because it is a relatively expensive process with all the legal fees, court filing fees, attorney ad litem fees. It just all sort of adds up. So now let me just kind of mention lastly, the determination of heirship can be confused with an affidavit of heirship. I have a whole nother video about affidavit of heirship. That's not even a court process. So an affidavit of heirship works in a very, very few situations and really only works if the deceased really only had a piece of real estate, and everybody's sort of in agreement. Affidavit of heirship is a non-court way of dealing with that little asset. And then there's another little process called small estate affidavit that also goes through the probate court. And determination of heirship is not that either. Determination of heirship is kind of the normal way to go if a person dies in Texas without a valid will. So that's called determination of heirship. I hope you found this video helpful. Again, my name's Isaac Shutt. I'm an estate planning attorney licensed both in Texas and in Wyoming.